right. So, we are here from Milgram and Dascom. My name's Maddie Shaner. I'm an attorney, and we are here to talk about business foundations, entity formation. So this is, our firm is putting on a series of 3 business foundations sessions this week. This is the first of those 3. There's another one on third-party contracts on Wednesday, and one on intellectual property on Friday. We want to thank you for joining us for the 11th annual Denver Startup Week, and thank the title sponsors, Amazon, Capital One Cafe, Dell for Startups, and the Downtown Denver Partnership, and with a specific shout out to the designer track sponsors, Public Works and Battery 621. By attending this session, you are agreeing to follow the Denver Startup Week Code of Conduct and to being photographed and or recorded on video for this session. Share your experience online by using the hashtags that are up on the screen. Here are some more sponsors.
Hey, sponsors.
Thank you to the sponsors who make all of this possible. Yeah, Business Foundations. I'm going to kick it over to John.
Not working? Working. There we go. Okay. Yeah, we're a Denver-based law firm. I like to say we're small but mighty. We can handle pretty much anything that a business needs. We're 17 attorneys now. We're a B Corp. We're 1%. And with that, I will not talk much more about Milgram and Dascom for the rest of this presentation, except to say that we are not your lawyers. So anything we tell you today is for informational purposes. We'll do our best to answer our questions and to be a really valuable resource for you. But there is no attorney-client engagement as a result of this presentation. So that is the disclaimer. We're going to be talking about entity types today. So as Maddie mentioned, we have 3 presentations this week and then 1 additional presentation on NFTs. Oh, that's much better. But the 3 presentations we're giving are first on entity types, second on contracts, and third on intellectual property. And these are largely what I view as the 3 blocks to starting any business. An entity is the first thing that you should do. It's the first thing you should knock out of the way. And so when you look at entity types, there's really 4 different subcategories that we're going to be talking about today. There are others, such as nonprofits or public benefit corporations, which we know quite a bit about as well. But based on kind of being a startup and in the position that you're in, you likely are going to fall into one of these 4 buckets, and we're going to strongly steer you towards the latter 2, being a limited liability company or corporation. So we'll just talk sole proprietorship, partnerships, and frankly, why nobody should do those things. Limited companies and corporations. And by the end of this presentation, maybe I'll try that one. Is this better? By the end of this presentation, is this better? Okay, a little bit. I can just talk loud too. By the end of this presentation, you should be able to explain why it's important to have an entity. You should be able to make your own LLC, which Maddie is actually going to walk you through during this presentation. So if you have your computer, you can get this done during this presentation. And lastly, you'll understand, consider when electing an LLC or a corporation for your entity type, and you'll understand a bit about tax and what kind of I get from those. And feel free, there'll be time at the end for questions, so please jot down any questions. We're happy to answer anything you have. So, starting off, sole proprietorships and general partnerships. These are kind of like the default of what happens if you don't create an entity. So I go outside, I start a lemonade stand right out here. I'm taking the money, I'm putting it directly into my bank account. John's Lemonade right outside. That is a sole proprietorship. If you guys right now are designers and you're doing design work for a friend and they pay you, you are a sole proprietorship. This is something that you should not be. It is highly dangerous because if you do something wrong, then your personal assets can be attached to any judgment against you. So let's say, you know, I'm driving with my lemonade to the corner where I'm going to set it up, and I run into somebody. Well, I was in the course of my duties trying to run my lemonade stand, but I also didn't have an entity for liability protection. So now that individual I hit can bring lawsuit against me, and proof, they can attach all of my assets, my car, my house, anything that I have. So having an entity to create liability protection is really, really important. You don't want to be a sole proprietorship. There's very few good things about being a sole proprietorship other than it is very easy to start. It's relatively true of a general partnership, except that there's even more reasons not to do it. Now, in the investment world, there can be some reasons, but for most of you guys, a general partnership would exist when you enter into an arrangement with somebody else to run a business. So, for example, but with no legal entity structure. Imagine I still have my lemonade stand. Now Maddie's out there. Maddie and I are running this out there together. We own the lemonade half and half. At the end of the day, we split our profits, we go home. Well, that's all well and good, except once again, we still have no liability protection. And not only that, but now you can be held jointly and severally liable for the actions of your partner. So Maddie's driving home and runs into somebody in the crosswalk. Now I'm responsible for that. And that creditor can go after my personal assets because Maddie and I are general partners of each other. So we do not want to be sole proprietorships. We do not want to be general partnerships. They're loath with of liability there. And with the exception of some kind of investment vehicles, you largely don't see these things anymore. And that's because it is very easy to put together limited liability companies and corporations. Less so corporations, but limited liability companies are very simple. So I'm going to pass the mic to Maddie to talk about limited liability companies now.
Thanks, John. So limited liability companies are registered with the Secretary of State. You do have to have a number of organizational documents. These include articles of organization, which I'll walk you through forming, and operating agreements. But the beauty of a limited liability company is that it's an incredibly flexible structure. It has a lot of the flexibility that you would see in a sole proprietorship or a general partnership, with the added benefit of personal liability protection, as long as you're maintaining corporate formalities, which we'll discuss. Limited liability companies, the default tax structure is a partnership, so those have pass-through taxation. So like a sole proprietorship or a general partnership where you'll see we don't have to file a separate tax document for our business, that is in certain instances the same with a limited liability company. You'll also see that with a limited liability company, we're not paying two levels of tax. We're not paying a corporate level of tax as well as tax personally. Just any distribution that we receive will be taxed at your personal tax rate. John will talk a little bit more about this later. So what we want to do now is actually just form a limited liability company. If you have a computer with you, take it out. You can do this right along with me. We're going to go through the process of setting up an LLC. Currently, the Colorado Business Fee Relief Act, which was implemented on July 1st of this year, means that it's just $1 to create your LLC. That is anticipated to last for the next year. It's still $50 to create a corporation, but $1 to create it's normal is a great deal. So please, even if you're not doing it right now because you don't have a computer with you, do this soon. I'm going to open up my browser. We are going to form an LLC. We are going to form John and Maddie's banana stand.
No lemonade stand.
There's no lemonade stand here because the lemonade stand is where we're going to get in trouble, but there is always money in the banana stand. So we want to form our business. We're going to go to the Secretary of State's website. The first thing that we want to do to form our business is make sure that our name is available. I'm on the wrong page here. But we want to first run a name availability search. And I'm going to ask John to type because I have a microphone in my hand. So first we want to do is type our exact name that we're looking for and make sure that it's available. We want to use the exact name, meaning we also want to include the entity type because that is critical in making sure that your entity is formed correctly. Oh, look, our name is available. We can form John and Maddie's Banana Stand. But what a name availability, search the business database. We want to make sure that our name is not confusingly similar to something that's already operating in Colorado, especially if we're a consumer-facing business. This does not mean that there's not going to be any problem with your name. It does not mean that you're not going to run into challenges when you try and trademark. That is something you're going to want to attend John's session on Friday to learn more about. But in this case, look, John and Maddie's Banana Stand, LLC. There's nothing even close to this that's coming up when we search this in the name availability or in the business database. So we should be good, at least in Colorado, to form our business and operate with some safety. This is not all safety. Maybe there's no Nike based here in Colorado, and we could form a company called Nike here in Colorado, but that doesn't mean we're not going to run into trademark problems elsewhere. So what we want to do is we are going to form our business, file a business document, create a new record. This is a new business. We're going to start with an LLC. We're going to go to that second bullet point, limited liability company, so that we can form our company. If you were not attending this session, there's a checklist on there that can help walk you through this that John's scrolling through at the moment. Tells you a lot of information. We're going to condense that down into something a little bit more digestible here. This is why lawyers exist, so we can read the very lengthy text of the statute. Okay, we're going to go back. No? Okay, click next. We are not forming a professional services company. Professional services companies tend to be things like law firms, things like doctor's offices. Those are called PLLCs. As the website tells us, the most common choice is no here, and that's what we're going to do. We're not forming a professional services company. The website here does helpfully remind you that you need to include some variety of LLC in your name. This is a flag to consumers that you have some liability protection here. We already checked our name, so we are going to, sorry, John. We are going to use our name. Make sure you use the LLC. Okay. We're going to put in our street address. In the state of Colorado, you are required to use a physical street address. If you have a P.O. box, you can use that as a mailing address. We are going to use our law firm's address here, but again, this is something that you're going to just want to type in your address. Pretty simple. Technology is always fun. Okay, we're going to use the same mailing address as our street address and click next. Sometimes it tells you your address is not real. Don't always listen to it if you know your address is real. The next thing is your registered agent. In any state, whether it's Colorado or elsewhere, you need a registered agent. That needs to be a person or a company physically located in the place where you are creating your company who can accept service of process. That person, or that it either needs to be a company or someone over the age of 18 who can, if you are getting sued, say, yes, I represent this company, go ahead and sign off. Here, we're going to act as our own registered agent. If you are working with a law firm, often law firms will act as registered agents for their clients. Again, please don't use us, we're not your attorneys. Or you can, there are companies out there who provide this as a service, but you do need a registered agent. Provide their address, so if someone goes to sue you, they can find your registered agent. And you need to confirm that that person has agreed to be your registered agent. So again, reminder, we're not your lawyers, we're not agreeing to be your registered agent. But if you are using a registered service company or a law firm, make sure that they have confirmed that they will act as your registered agent. Okay, this is one of the big stumbling blocks as people form their own companies. LLCs are owned by their members. So often people will think, who manages my company? I do. I'm the owner, I'm the member, I manage my company. We want to avoid this. We want to create as much separation between you as a business owner and your business as possible, even if it appears fictitious. So we always want a company to be managed by a manager, so that it has some separation there. We also want to make sure that if you wanted to bring in a CEO who doesn't own part of your company, they can have management rights but not membership rights. Or conversely, if you wanted to bring in investors as members but not give them management rights, you still, again, have created that separation where the managers and the members are separate people. And we need to confirm that there's at least one member of our company. Here it's both me and John, so you can go ahead and say yes. Okay, then we need to tell the Secretary of State who is forming the company. Here, John's gonna go ahead and do this for us. It can be formed by an entity, so again, if we're a law firm forming for a client, we will often do this. Trusts or estates can do the same thing. You can have more than one person forming your company, but you only need one. Additional information, this is typically not necessary. Anything that's on your articles of organization is going to be public record, meaning searchable by anyone and everyone who can access the Colorado Secretary of State's website. So often we'll avoid putting information in here unless it's strictly necessary. If you wanted to say list the initial members of your company here, you could do it. But again, not necessary, so we'll often just say no and move on to the next step. Do we want this filing to take effect immediately? Here we do. We want our liability protection to start today. You cannot backdate the effectiveness of your LLC, but you can date it sometime in the future. You can delay its effectiveness. Typically, most people are not going to delay effectiveness of their articles of organization. We will sometimes do it if we are in late December to avoid, for tax reasons, to just say we'll start at January 1st. And then we'll have to enter our filer information, indicating that we are not perjuring ourselves and forming a company on behalf of someone else without their permission, and that we want to make sure. Apparently the mouse on the laptop is really resistant to whatever John is trying, or we're freezing, both of which are really fun. I do. Hang on. Locate a mouse real quickly.
So the two biggest obstacles that we usually see people, or biggest mistakes that people make, this is a really straightforward process, as you can see. Two biggest mistakes we see people make and have to correct is not putting LLC in the name or LTD, because it will let you file without that, and you have to go back and amend your filing. The second one is that you click member managed, because that just makes your company very, very inflexible, as Maddie was talking about. Manager managed, you can always appoint yourself as a manager being a member, but it limits your flexibility going forward. Not huge mistakes, easily fixable, but as long as you're doing it, might as well be doing it right.
Yeah, and this last part, signing up for email notifications or text message notifications. I don't often sign up for text message notifications, but the email notifications are important. It will remind you every year when you have to file a report indicating who your registered agent is or confirming that all of your information has remained the same. They'll send you an email. They'll also send you an email anytime someone files a document for your entity. So if someone were to fraudulently file a document on your entity, you would be able to see that. Last piece of information is that we just want to review all of this. We want to make sure that all of our information is correct. We can view it as a PDF. In a lot of states, you have to just free-form this articles of organization. Colorado makes it very, very simple to create your entity. They provide you the form. They walk you through all the steps. It's currently just $1 to form your entity. So we're going to take questions at the end, but if you can hold on to that, I would appreciate it. So yeah, just check all of your information is correct. And then the next step is to pay. We are actually not going to form John and Maddie's Banana Stand LLC, but again, just $1 to form it right now. So highly advise doing that in the next year. Okay, so we're going to go back. The next piece of the next step you want to take is to obtain an EIN. An EIN is a social security number for your business. It's an employer identification number. It's how the IRS identifies your business. If you are a single member LLC, you do not need an EIN, but may want one. It's the number you put on forms or contracts when you're working with other companies. So if you don't want to share your social security number, having a separate EIN specifically for your business is helpful. There's a form that's linked in our slides, and our slides will be posted after. With the IRS, that's similar to the Secretary of State's Article of Organization. It's totally free to get one. It'll walk you through all of the information that you need to put in. Things like who the responsible party is, so that's you with your social security number. It'll ask you questions about the type of business you're starting, why you're starting the business. If you have employees, you'll need to indicate that. Again, this information is not set in stone. You don't have to know exactly how many employees you're going to have and tell that to the IRS right now when you're starting your business. It's an estimate. Give it your best guess. Tend to estimate high just so that it makes it a little bit easier. But make sure you get an EIN. This leads us to maintaining your liability protection. So once you have your business, whether it's an LLC or a corporation that John will talk about later, and you get your EIN, this is kind of the critical piece. The number one thing that you can do to protect your personal assets in your business is to keep your personal and your business finances separate. Open a bank account that is specifically a bank account or multiple bank accounts that is specifically for your business, using that EIN, using your business name. Use that account for your business and only for your business. Do not use it like a personal piggy bank. Do not donate your personal money to that account without documenting it somehow. Transfer it to that bank account instead of just paying something out of your personal account. If you're, say, paying a security deposit for a lease, don't take it out of your personal account. Transfer it first to the business's bank account and then pay it from the business's account. If John and I are sharing this business, we want to share the responsibility of that bank account potentially. We need to know what's going on in there. But we also want to make sure that the finances are clean and clear and that they belong to our business, which goes along with keeping diligent written records. It's, seems like a pain in the butt up front, but is worth it in the end. The next thing is an operating agreement. This is the other major organizational document for an LLC. This is critical if you have a multi-member LLC. If you are starting your business with a business partner, John and I, starting John and Maddie's Banana Stand LLC, we need to have an operating agreement. We don't want to rely on handshake agreements. I like John a lot. I trust him. We're starting our business. Things are great. Awesome. Still not going to proceed without an operating agreement. They cover all of the important information about governing your business. So management rights, how you buy or sell interests, if someone can join your business and how they do that. Just kind of like whether you can take out a loan, whether you can buy or sell property, all of that. And we'll also talk about who can sign agreements on behalf of your company. And this is kind of pretty critical. When you're dealing with third parties, you want to know who has the authority. And this, there's a session from our firm on Wednesday about third-party contracts that will tie into this pretty well. So that's kind of, even with a single-member LLC, you still are going to want an operating agreement just because it sets out exactly how your business is governed, including what happens sometimes if you die, right? If you die and leave your business, what happens to your business? So that is LLCs. I'm going to hand it back to John, who's going to talk about corporations.
Thanks, Maddie. All right, so you've hopefully made your LLC now. If you haven't, you probably should. Or you could consider another corporate entity structure type. So the other one we're going to talk about today is the corporation. Corporations are very traditional. They've existed for a very long time. LLCs, on the other hand, have only been around for a decade and a half, 2 decades now. And so as a result, a couple things are true. One is that the body of law around corporations is much better built out. And 2 is that there's a lot more statutes about corporations. So whereas, like Maddie just said, you really need an operating agreement for an LLC that's going to spell out how the LLC is run. a corporation has certain statutory obligations. Now, it makes it a lot more cumbersome to run an organization that is organized as a corporation than as an LLC, but it also provides investors with a lot of confidence. They know what they're signing up for. Whereas when you're investing in an LLC, you have to really read and take apart the operating agreement to understand what your rights are. So, there are a number of organizational documents that are still required. You need articles of incorporation, which are going to specify the number of shares you're authorized to issue and what the rights of those shares are. And that's going to be a publicly facing document. So I could go right now on Edgar or on the SEC website, and I could look up all of the biggest corporations and what their articles of incorporation say and what their share classes rights are. So that's pretty critical. When Maddie was going through the LLC organization, there was no additional information that we needed to attach. Almost every time that you make a corporation, you're going to be filing additional attachments because you're going to be spelling out the rights of these investors. So that increases investor confidence because they know, okay, when I'm coming to this company, here's the number of shares that they're authorized to issue. Here's how much of that I'm buying. So you're buying a portion of a bank of authorized shares. You also know what the rights are associated with those shares. So large-scale investors, large institutional investors, are typically much more inclined to invest in a corporation than an LLC. So at the onset, when you're deciding, am I going to be an LLC or a corporation, one of the litmus questions is, how flexible do I need this to be, and what am I looking for long-term? Am I looking for a long-term growth strategy with some venture capital partners where CalPERS is going to come and infuse $20 million? Or am I going and making a banana stand with Maddie outside that's going to cost us, $75 to set up, and we just need that liability protection? So when you're thinking about LLC versus corporation, you want to be thinking about what the long term is. And that's going to come into play when we talk about tax elections here in a second as well. So as Maddie mentioned, an LLC is owned by the members and then typically managed by managers who are appointed by the members. Let's try that. That sounds good. Thank you. Ooh, this is better. Great job. So a corporation is owned by shareholders. The shareholders have the statutory right to vote for directors. And their voting rights will be spelled out in those articles that we talked about, or in Delaware it's called a certificate. Each state has it slightly different. So I know what my rights are. I vote for a director. The director is going to hire, or the directors, the board of directors are going to hire the C-suite individuals or appoint. And then those C-suite individuals are going to report back. Have a level of accountability where the shareholders have input. They're going to be taxed twice. They're going to be taxed at the corporate level, corporate tax rate, and then if they issue dividends, those dividends are going to be taxed as well. Whereas when Maddie mentioned an LLC having pass-through taxation, if Maddie and I have John and Maddie's banana stand, and it's outside, and we have all the money in a cash box, that money, that income is going to be imputed to us for tax purposes, so we'll pay personal taxes on it, but the LLC will not pay taxes on it. So C Corp gets double taxation, but it also has the statutory benefits of being a comfortable structure to invest in that's very predictable. Additionally, if you're not going to issue dividends, the corporate tax rate very well might be lower than your individual personal tax rate. So if you're just holding the money in the corporation and you never issue dividends, you may actually end up paying a lower tax rate just by keeping the money in. So same deal, I want to point out again, and I want to reiterate this because we talked at the beginning about the liability you're exposed to by being a business. As creatives, this is actually fairly substantial. If you accidentally take an image from the wrong website, statutory damages for willful infringement are $150,000 per instance. So you're doing this on your own. Really important to get that liability protection by making LLC or corporation, and then getting that EIN and keeping your finances separate. So you're going to buy something for the company, put your personal money into the company bank account, and you buy it for the company bank account. You're going to pay yourself, you get the money into the company bank account, and you pay yourself from the company bank account. You're never commingling assets, because that eviscerates that liability protection. And that's the same for an LLC as it is for a corporation. You can't commingle assets. So, I'm going to talk quickly about tax elections, and then we'll take questions. Default tax election for a corporation is to be taxed as a C Corp. The default tax election for an LLC is to be taxed as a partnership. We get a lot of questions about S Corps, and everybody's accountant seems to want them to become an S Corp. An S Corp is actually just a tax election. An LLC can choose to be taxed as an S Corp, which is really beneficial, because then you have all the flexibility of being an LLC with the potential tax advantages of being an S Corp, which I'll talk about here in a second. But if you incorporate as an S Corp, you still have to do all of those corporate formalities that a C Corporation would do. So you have to have bylaws and issue shares and do all sorts of stuff. Keep minutes, yearly meetings of the shareholders to vote for directors. In an LLC, you don't have to do that. So you very well might want to consider incorporating as an LLC and then making an election to be taxed as an S Corporation. And we'll talk about some of the different kind of contingencies here in 1 second. But what I'd like to really kind of hammer home right now is at the onset of the plan for your company, you need to be thinking about where you want to go. Because the entity selection that you make is going to have a significant bearing on how that goes and how you get to that point. So for example, do you want to have employees who are also owners? In an LLC, there is very, very limited ability to do that. The tax code says that you can't have somebody who's reporting income from an LLC taxed as a partnership with both a K-1 and a W-2. So, you could have an LLC that opts to be taxed as an S Corporation, and then the owners can be both K-1s and W-2s. But if it's just an LLC taxed as a partnership, issuing employee equity is very difficult. There are profits, interests, there's other kind of creative ways. But if you know that that's something that you're going to want to do long term, you may want to stay away from the LLC formation structure and go with a corporate entity structure. And there's other kind of little nuances and complications here to each one of these. So I put together this table, and I'll just walk through this quickly, but there's long-term implications for all of these things. So, as an LLC, your default taxation status is as a partnership. That means that all the income is going to pass through. If Maddie and I own our banana stand, we're not W-2s of that banana stand. We are K-1s. And we're receiving all of our income from the banana stand on our K-1 tax forms as partnership income. We'd be paying ordinary income tax plus maybe employment tax on that as well. So it's probably a slightly higher rate. If we're an LLC and we make an S Corp election, Maddie and I can pay ourselves twice. We pay ourselves a small, reasonable W-2 salary, and on that salary we're going to be paying ordinary income tax plus Social Security, all sorts of employment tax, a higher tax rate than what we issue ourselves as distributions. So, let's say Maddie and I make $10. We can issue ourselves $1 each as W-2 salaries. We have $8 left. We each get $4 in distributions. That first dollar out, that's the W-2 salary, is going to be taxed, most likely, depending on your situation, at a higher rate than the distributor rate. So that's the benefit of the S election, is that you can be both a W-2 and a K-1. So if you're going to have a small corporation or a small LLC, literally stands for small. S stands for small. Then, and you're not going to go big, you're not going to sell a bunch of shares, then this might be a good election for you to make. However, there are some restrictions on S corporations. And so once again, thinking forward about what you want your organization to look like, this is really important. An S corporation can only have 100 shareholders, no more. You can have no entity shareholders. So now you're looking for venture capital money, do not be an S corporation. They're not coming to give you money because we can only have individual investors. No foreign investors. And then most importantly, you can only have one class of shares. So, if you are the owner, if Maddie and I own this company together and we're on equal footing, great. 5 years from now, the banana stand's blown up because there's always money in the banana stand. And we want to hire somebody else. If we're going to give them ownership, they have to have the same class of ownership that we do. In most venture-backed companies, you have a corporation that is a C Corp with preferred shares and common shares. Maybe there's other structures of shares there as well. But there's a lot of good reasons to do this. Because the preferred shares are being bought in. And they usually have some superior rights, like a liquidation right or liquidation benefits. whereas the common shares do not have that value. So the common shares are technically worth less money until there's a liquidation event, in which case, let's say it's a really good liquidation event, everybody's probably going to join in one class of shares. What that means, though, is when I issue these common shares, the value of those shares is lower than the preferred shares. So if you're issuing common shares to an employee, any shares to an employee, there's an income event. You're getting income. I'm just paying you in shares. So we want that share value when you're paying out in shares to actually be very low, so that the employee doesn't have what's called phantom income. If you just paid me $100,000 in share value, I have no cash and no liquidity. I have to report that $100,000 to the IRS, and now I got to pay 30% of it in taxes. I got to come up with $30,000 out of nowhere. So we want to sell the preferred shares for a high value, artificially suppress common shares, so we can issue them as sweat equity to employees. You cannot have two classes of shares in an S corporation. So, if you're thinking about employee equity, at the onset, you may want to say, let's be a C corporation. Let's think about how we want to structure this. So these incidences of decision that you make at the onset of creating your entity are going to have ripple effects down the road. I will get to you, I promise. You can change entity types. You can go from being an LLC to a corporation. It's much harder to go from being a corporation to an LLC. You can do that as well. I'm just going to walk through the rest of this table, and then we'll spend the rest of the time answering questions. So, taxation status, a partnership is passed through. An S Corp has these multiple levels. You can be a K1 and a W2. And a C Corp has double taxation. That's the most flexibility level. You can have W1, W2s, and nobody gets a K1. They would get what's called a 1099 div, which is a 1099 form that you get for receiving a dividend. Employee equity, very difficult in an LLC with just a traditional structure. Some CPAs might be willing to do it, really not supposed to. In an S corporation, you can have employees as shareholders, but you can only have that one class of shares. So anybody who's coming in is coming in with the same rights and same obligations and same value. C Corp, sky's the limit. You can do whatever you want in terms of employee equity, well, within reason, but you have a lot more flexibility there. So limitations in the partnership, very hard to have employee owners. I always mention the OFAC SDN list. This is basically like making sure that, you know, Vladimir Putin's probably on the SDN list. I don't know. Evil nationals are not able to invest in your company, so it's true of everyone. S Corp, 100 shareholders, no entity, no foreign shareholders, one class of stock. And for a C Corp, it's just really OFAC. I'm going to talk about one more thing, and I'm going to keep this actually relatively quick, but there is one more benefit towards a C corporation, and this is particularly aimed at startups in tech, retail, wholesale, and manufacturing spaces. This is called Qualified Small Business Stock, QSBS. This was essentially legislation that was passed to incentivize people to invest in early stage tech companies in the thousands, 20 years ago or so. And it's been re-upped and re-upped and re-upped. And essentially, if you invest in a company or you receive shares from a company before they have $50 million in assets, and it is in one of these eligible bridges, tech, retail, wholesale, manufacturing, and then after holding those shares for 5 years, you liquidate, you can get out of that with paying zero federal tax right now. Zero, which is pretty substantial. And when you think about the wonderful sponsors of this presentation here, Jeff Bezos starting that thing out of his garage, getting that, millions and millions of dollars of shares, basically completely tax-free. If your plan is to develop a tech company, hold the shares for 5 years and exit, I mean, I would probably be telling you to go C Corp, because this is pretty compelling. Now, there's always a chance that they close this. They've talked a lot about closing this loophole. They haven't for going on 7 years. There's obviously a lot of folks who probably don't want to see them close that loophole. But even if they do, they've talked about closing it to half the cap gains rate, which is obviously way better than what you get on just an ordinary loophole. So, I'm sure I've thrilled you all with the riveting tax portions of this conversation. Maddie and I would be happy to take any questions you have now, and hopefully we'll see you at the banana stand as well. All I mean, it really depends on your individual situation, but what I will say about it is, in an S corp, because you can't have multiple classes of shares, if you bring somebody in and then you make a distribution, that distribution, with very little exception, has to be made in proportion to your ownership interest. So, you know, let's say Maddie and I are working together, I own the whole thing, I bring her in as a 10% owner of an LLC being taxed as an S corp. We're on the same footing. So if I want to now take out $100 as a distribution, Maddie has to get 10 of those dollars. So it's relatively inflexible. That being said, if you, Maddie and I are partners, 50-50 partners to start out. And the expectations are very clear. Here's what we're going to do. Here's how money's going to come in. Here's what you're going to be contributing to the business. Here's what I'm going to be contributing to the business. We can minimize each of our tax obligations by remaining an S corp, but we just have that inflexible nature of distribution. So there are other ways to get employees as owners of an LLC. You can have what's called phantom equity, where essentially they're not getting paid. They're not getting paid ownership of the company. They're getting paid an equivalent measurement of how much the company has increased in value. So it's not actual ownership. It's just a right to receive payment. It's a little bit more complicated. A lot of LLCs are moving to that. Phantom equity or profits interests. There's a couple different ways you can call it, a number of things in the structure. There's not necessarily one right answer. This is the short answer to your question. Thank you.
So when you form an LLC, does it matter if your name is capitalized or not, from a federal perspective and from like a state perspective? Like if I want to do ABC LLC, can I do capitalized ABC, or would that be different than my non-capitalized ABC?
So it doesn't really matter, is the short answer to your question. Maddie mentioned checking the name availability database. If you have an exact match, by the way, the Colorado Secretary of State website is like probably the best I've dealt with. We've dealt with 40 plus states at least. It's very, very user friendly. What they do is they'll spit you out that articles of organization and certificate of good standing like immediately, and they're basically running your exact name against what they have in their database, and if it's different, they're going to let you have it. So from the actual entity creation standpoint, it's not that important. If you come to my presentation on Friday on the intellectual property standpoint, it is fairly important. Because, like Maddie said, if there's no Nike created in Colorado, we could go on the Colorado Secretary of State website and make Nike LLC right now. Now, our good friend Phil Knight would probably not be too pleased about that, and we'd probably receive some correspondence from the good folks at Nike not too long afterwards. So running the name knockout search is not the only thing. Now, one other thing I should mention is when you get your EIN from the IRS, they're not going to let you put any characters into that name. So, like, we typically file with entity name, comma, LLC. You can't put that comma into the federal database. And if your company name is spot on to somebody else's company name in the federal database, it won't let you get an EIN. So some states require you to actually get an EIN first. Utah does that. But the short answer to your question is it doesn't really matter. Whatever you want.
And in terms of the EIN, I'm just going to follow you up really quickly. If it tells you that you can't create or can't obtain an EIN through the website because your name is too similar, there are two things you can do. One is to just change your name in the Colorado Secretary of State's database, add some numbers, something like that, and then you can file a trade name. The other option is to file your EIN by paper, but that will take you over a month, so don't do that. You can do it, but it's time-wise is a really not worthwhile way to move forward.
Add holdings or
If you have a C Corp that gets acquired by whomever, you're like, hooray! And that C Corp has been paying corporate taxes every year. Does it also have to pay taxes on the capital gains from selling all the shares?
So the capital gains will be taxed when the money is distributed from that entity to the individuals. So if you sell your C Corp and then the money comes out to you, and you're not QSBS, then you're going to pay individual income tax that's reported on a 1099 TIP. Otherwise, the C Corp is paying its own corporate tax every year on whatever its assets and items are.
So but the entity itself doesn't have to pay taxes at the time of the sale, just the individual owners?
So it would depend on how the sale was structured and where the money was going. So there's two typical ways that the sale would be structured. It would either be a stock sale or an asset sale. So if the C Corp sold all its assets, then the money's going into the C Corp. And then it would be taxed by the individuals at the distribution, the time of distribution. If it's a stock sale, then the shareholders are selling the entire company, not just the assets of the company. And then the money would be going directly from the buying company to the shareholders. And so they would pay at the time so that the company wouldn't be paying additional tax the individuals would in that situation. Yeah.
Her question spun off a question in my mind. So I was an LLC 5 years, and then after the 5th year we changed to LLC filing as S Corp. We're currently selling like 2 websites and domains. We're a web company, and it's the first time we're doing that. When we sell those, obviously we get taxed. My name's on the sale and the business. We get taxed through the S Corp, or would that get taxed individually?
So the LLC is a pass-through entity. Everything's going to be taxed individually. Now, a lot of times what LLCs will do is twofold. Either they'll issue what's called a tax distribution to members. So Maddie and I have our LLC. We made $10. We each owe $1 in tax. The company just gives us $1 each to pay tax. The other thing that will happen is the company will just pay the taxes for us, but that technically also categorizes as a distribution. It's just taking out an extra step of giving us the $1 and then making us make the payment.
So if we left it in the S Corp and didn't touch it, it would qualify, like the profits would qualify.
Excuse me, the profits would still pass through.
Okay.
So whether or not you made a distribution, the members of that LLC are going to have to pay taxes on whatever is in the LLC.
Gotcha.
It's just a matter of whether you want to help them to cover that phantom equity or phantom income.
How hard is it, and we have to go through the whole process, but to switch from an LLC to a C Corp?
So the short answer is it's not super hard, but it depends on how many owners you have and how much they're in agreement that this is what they want to do. Provided everybody's willing to agree, it's pretty easy.
And also,
Consulting, hold those in 2 different buckets, have a holding company at the top. We do that quite a bit with clients. Especially because those single member LLCs just have pass-through taxation, so you're really just filing the taxes for the parent.
If you have that set up, do they all have to be the same thing? Like, do they all have to be LLCs, or could the top be a corporation and the little guys be an LLC?
That's typically what we do.
Okay.
That's probably the most traditional sort of structure is with the corporation at the top and then a bunch of single member LLCs following. These are really good questions. Also, our email addresses are both up there. We have cards on the table up here. Please feel free to reach out to us, follow up. I think a lot of this stuff is stuff you guys can do on your own, and that was really our goal to set you up for that. I will say, like, making an operating agreement on your own, unless it's a single member, not highly recommended. You see a lot of mistakes and litigation that happen there. And then like shareholders agreements and anything on the corporate route, you probably want to involve counsel for. If you're making a basic single member LLC, you make your LLC, get your EIN, download an operating agreement, I'll never say that again in my life, and feel relatively comfortable. This is basically an agreement with yourself. But if there's one thing that you take home today, especially as creatives, go home and if you don't have an entity, make one. We have seen it far too often where somebody is operating with the best of intentions and accidentally pinches somebody's clip art who is just a completely predatory person, and then they go after that uninformed graphic designer who unfortunately took the wrong piece of clip art and now is so, form that entity. $1 bomb.